there, my name is Sherry Shear, and I'm a partner at Labor Rights Law Office. And with me is Rebecca Jackson. She's an associate lawyer at Labor Rights Law. I understand, Rebecca, you've got a series of questions for me today, but before we kind of start going through those questions, why don't you tell me a little bit about how you came up with these questions to begin with?
Okay. Well, before I became a lawyer, I was a registered nurse and I belonged to 2 unions. And so I've been exposed to the collective agreement and grievance processes, but I never really understood their importance until I became a lawyer. So I would just like to ask you some questions today and clarify some of those little details.
Sounds great. Let's get started.
All right.
What's your first question?
So starting from the beginning, why are grievances important?
Grievances are important because they may be the only mechanism available to the employee for pursuing concern or issue that they may have with respect to their employment. For example, human rights concerns can potentially be pursued through a grievance filed under the grievance process outlined in the collective agreement, or through filing a complaint with the appropriate federal or provincial administrative board that's been assigned to regulate the human rights legislation. On the other hand, other issues such as unjust termination, failure to pay the appropriate wages, or failure to comply with the seniority list, for example, in terms of recall or layoff of an employee, those are issues that fall squarely within the collective agreement and therefore can only be pursued through the grievance process. An employee, for example, will not be able to file a lawsuit against their employment for unjust termination. If that happens, the grievance process is the only means that they can pursue that issue against their employer.
Okay, so if there's a grievable issue and a person doesn't grieve that issue, what's the risk?
Well, they potentially may be left in a situation where they may not have any recourse available to them. They may not be able to get a remedy for the unjust termination or the unjust treatment. It's really important that if an employee has certain concerns about terms and conditions of their employment, they speak with their union representative or shop steward, bring their concerns to the union's attention, and attempt to pursue or resolve the issues through a grievance process. If you fail to file a grievance, you may be left in a situation where you won't be able to do that later on, because then you may have gone past the time limits outlined in a collective agreement for doing so.
Okay. So once a grievance is submitted, what happens?
Typically, collective agreements outline a few steps within the grievance process. They either call it steps or levels, and there are often multiple levels depending on the employer's organization of their management team often. What happens is the initial steps or levels of the grievance process provides a mechanism for the union, the employee, and the employer to meet and informally discuss the concerns raised in the grievance and try to settle or resolve those concerns. Now, if typically the last or final step in the grievance process is the referral of the grievance to an arbitration process, where an arbitrator who is a mutually appointed adjudicator, somebody that the union and employer mutually agree upon to adjudicate the grievance, the arbitrator reviews the grievance and the basis for it and makes a decision on how that grievance should be handled, whether it should be upheld and the employee receives a remedy for the employer's breach, or whether it should be dismissed because there's no merits to it.
So once a grievance is filed, who gets to decide how far it goes?
The decision in terms of what to do with the grievance lies solely within the discretion of the union. And the reason for that is the union has a duty and an obligation under the Labor Relations Code to represent the membership as a whole in a fair, non-arbitrary, and non-discriminatory manner. Often what that means is that, again, they have the freedom to decide whether to refer the grievance to the next step or ultimately to arbitration or not. There's a lot of information in terms of how the unions are supposed to make these decisions, and which we won't be able to cover right now necessarily, but I do recommend if an employee is interested in the law surrounding that, to check out the additional resources on our website that deal specifically with the union's duty of fair representation.
Okay, great. One question I've always had when I was a member of a union was, when a union steward or a union rep meet with an employer, are they on equal ground as far as negotiating the grievance?
Yes, absolutely. The union is there under its authority, as outlined in the collective agreement, to represent the employee. Therefore, they're absolutely there on equal grounds. The employer cannot use their position or the imbalance of power in those circumstances to try to coerce or intimidate the union representatives or the employee into accepting a certain outcome. So absolutely, they're on equal footing in all respects.
That would have been good to know.
Yeah.
Okay, so on to the arbitration. You said a grievance can go to arbitration. What exactly is an arbitration?
Arbitration is the process where a grievance gets adjudicated. As I referenced earlier, once a grievance gets to that last stage of the grievance process, the union has to make the decision of whether to refer the grievance to arbitration or not. If the union decides to refer to arbitration, the next step that happens in the process is the union and the employer mutually agree to appoint an experienced individual and an experienced adjudicator, often referred to as an arbitrator, to decide the merits of the grievance. The parties also mutually agree to be bound by the decision of the arbitrator. And the arbitrator will hold often what we call a hearing, which is essentially the parties meet at a mutually agreeable site, often a boardroom of some kind, and the union and the employer present their respective evidence, often through witness testimony, as to why the arbitrator should agree with each party's respective position. After having received the full scope of the evidence each party has to present, an arbitrator will take that information and decide whether to uphold the grievance or dismiss the grievance. And of course, if the grievance is upheld, the arbitrator will also be making a decision as to what would be an appropriate remedy under those circumstances for the employer's breach. And if the grievance is dismissed, that concludes the matter, and that's the end of the grievance process.
So to simplify it, would you say an arbitration is kind of like going to trial?
It really is. It's a private court of some kind. Without the public being present, the parties decide to deal with the issue amongst themselves by appointing a mutually acceptable adjudicator to decide their claim.
Okay, so all great information. So at the end of the day, how do I file a grievance?
The first step is for you to go and review the collective agreement, because the collective provisions of the collective agreement dealing with the grievance process outline whether you yourself as an employee can file that grievance, or whether you need to go and speak with a union representative to file that grievance on your behalf. That would be the first step you need to take.
Great.
Yeah,
Thank you.
you're welcome.
We hope you enjoyed our video today on collective agreements and grievances. If you are an employee in a unionized work environment and have a grievance or complaint, visit our website for more information or give us a call to book your free half-hour initial consultation today.